welcome to our channel once again. In our last video, we were doing the ECHR, and I got to Article 5, no, Article 6, which is the right to a fair trial. But today, there is information that has come over from Strasbourg, basically the head of the political arm of the European Convention on Human Rights, Alain Berset. He's the Secretary General of the Council of Europe. He's come up today to say that now the European Convention on Human Rights, or the Council of Europe, as it may be under, are willing to open conversation on the ECHR on the basis of the fact that does it actually need reform where migration issues are concerned. And indeed, he has said that they are actually open for some kind of reform. And his recommendation is for the UK to actually look at the idea of having the ECHR reformed rather than the UK basically coming out of it completely. Now, we know that obviously the Prime Minister, Sir Keir Starmer, is in support of the UK remaining in the ECHR, being the next step if one is unable to find justice within the highest court of the United Kingdom. And basically also just recognizing that Winston Churchill is actually one of the founding fathers, or the founding father of the Council of Europe, and obviously a strong advocate for the establishment of the court, the European Convention of Human Rights Court, which is in Strasbourg. And so Mr. Berset, what he's trying to say is that those who argue, obviously the likes of Nigel Farage and Kemi Badenoch, basically the UK Reform Party, and also some hard right people in the Conservative Party led by the shadow PM Kemi Badenoch, they are arguing that coming out of the ECHR will help UK to take control of its borders, taking back control, that slogan that was used by the then Prime Minister Boris Johnson to get UK to basically activate Brexit. Now, we know that Nigel Farage is definitely a charismatic figure in his divisive and sectarian politics, and he has been fairly successful in doing that, i.e. Towards people who do not find time to educate themselves in what ECHR brings to them, the benefits that it brings to this nation. So he's basically isolated a small section of it, which is the migration aspect. And even with the migration, it is only, the argument is just on illegal immigrants, the removal of illegal immigrants, and also maybe migrants, illegal migrant, and it's always illegal migrants with maybe some sort of criminal or terrorist sort of background. Currently, I think the law probably has not made that provision, and so some illegal migrants have actually had the opportunity to remain in a country when indeed they should be removed from that country. In reality, one can say that as an illegal migrant, they don't really have a right to be in a country, and therefore there shouldn't be so much of a difficulty removing or sending these people back to where they have come from. But obviously, there is always the need for their case to be assessed and decisions made, and these decisions potentially should be at the discretion of the respective nations. The other thing that had also been evident that the Secretary General of the Council of Europe, Alain Berset, is actually mentioned is also the fact that it's not just the UK that are seeking for some sort of a reform in the ECHR. Countries like Denmark and Italy and other countries, major players within the EU, are also seeking some kind of reform where migration is concerned. But as we heard from the previous video, from the retired judge Tim Ike from the European Convention of Human Rights Court, he said that the UK human rights laws are more than capable of dealing with domestic migration issues. So in effect, when you really do look at it, there may not be so much of a big problem. But obviously you have the likes of Nigel Farage in his divisive politics, and which he has done fairly successfully in trying to mislead this nation once again into exiting the ECHR by just using a very minor aspect of it, being the fact that maybe it falls short on some aspects of dealing with illegal migration. So these things can be reformed, as we have heard from Alain Berset, who is the head of the Council of Europe. And so these things can be done. He has also emphasized, Alain Berset is also emphasized, that the UK coming out of the ECHR, as has been argued by Kemi Badenoch and also by Nigel Farage, that this is going to somehow help us to take control of our borders. He thinks that these things can actually have a rather negative impact. It can rather have a negative impact on the UK. It does not bring anything positive. In effect, it will isolate the UK. That is number one. And it will also keep us out of that debate, the debate concerning migration issues in Europe. And so this is the reason why he advocates that the UK should actually engage in the dialogue, get involved in the dialogue, sit at the table, be at the table, have an influence in decision making concerning migration issues in the UK. So that is what Alain Berset, who is the boss of the Council of Europe, that is what he says. And so at this stage, I will just basically go on to continue from where I left off in the ECHR, basically just bringing out the articles and what it really says. For those who do not have time to maybe read, they may have that opportunity to listen to this video and educate themselves about the articles of the ECHR and how beneficial that is to this nation and to all the people within this nation, and also people in mainland Europe. And so we will carry on. The next video that I'm going to be talking about is actually the new Renters' Right Act of 2025, which is actually going to be helping a lot with tenants or renters in the United Kingdom. This act was basically gained royal assent on the 27th of October 2025. It was signed by the King, so it is now law. So the next video will be digesting and analyzing the impact of this new Renters' Right Act 2025 and how that impacts landlords and tenants, basically making the playing field level. So we are going to see, and also how that may also impact the housing market and house prices in the UK. So that is what is going to be the next video. So at this stage, I'm just going to switch to on screen and look at the remaining articles of the European Convention on Human Rights. Bear in mind that there are optional protocols to all these international treaties. So these optional protocols, to explain it to the layman, really means that whilst these articles were basically were established, there were certain things that were not necessarily taken into consideration at the time when they were established. Sometimes it could be things to do with capital punishment, the death penalty and stuff like that. And so these optional protocols comes in to basically correct or add on or to amend parts or whole, some parts of the articles. And so that is what the optional protocols are. It is likely that going through these articles, we may not necessarily cover all the optional protocols, but then it gives you the gateway to sort of further go on to explore these aspects of the European Convention on Human Rights. And we encourage people to basically educate themselves about these laws so that they will be well informed, so that they will not be misled, just as in the way that they were where Brexit was concerned. Today, the country is paying a heavy price for Brexit. Young people have lost their rights, which they usually used to have in going into mainland Europe, taking jobs and just having the freedom to explore in their lives. And so here we want to make sure that people are well informed before they jumped on the Nigel Farage bandwagon campaigning. And also Kemi Badenoch, she is actually in the main party, the Conservative Party. Sometimes it is a tragedy that maybe just seeking votes or seeing that the UK Reform Party are gaining votes, it causes a Conservative Party, which is a main party or a party that obviously have been in power for such a long time, to basically switch onto that direction as well. And so this is where we are. And so we'll carry on. So if you stay on, you get to know the remaining articles of the ECHR. Okay, so we continue from where we left off last time, and now we go on to Article 7, which says no punishment without law. And so, really what I understand about this article is that it's trying to say that if there isn't a law, let's say a person may do something that is not right. However, if there isn't a law at the time when this sort of act is committed or done, then that person cannot be punished. So this is my understanding of what this article is. And so it's only when there is a law against basically the act of that person that the person can be punished by that law. So we say Article 7 of the Human Rights Act. Article 7 means you cannot be charged with a criminal offense for an action that was not a crime when you committed it. This means that public authorities must explain clearly what counts as a criminal offense so you know when you are breaking the law. It is also against the law for the court to give you a heavier punishment than was available at the time you committed an offense. And so this is also very clear that the court cannot basically, if they punish you for a crime, it should be proportional. Yes. So restrictions to these articles, restrictions to the right to no punishment without law. The right to no punishment without law is absolute. This means that it cannot be restricted in any way. However, the Human Rights Act does not make an exception for acts that were against the general law of civilized nations at the time they were committed. It was this type of provision that allowed war crimes and crimes against humanity to be prosecuted following the Second World War. And so this is a very interesting side of this law, stating that it is absolute, and so no excuses can be made in basically addressing these breaking of law or punishment. But then what is interesting here, it talks about the fact that some of these laws may have gone against the general law of civilized nations. So these are the type of words or phrases that are used in these laws that are not necessarily good, because every nation is civilized, and therefore crimes committed in any nation indeed must be treated thereabout the same. And so here we are. So it talks about it is a good thing in a sense that probably at the time of the First and Second World Wars, maybe certain atrocities may have been committed that were not necessarily breaking any law, or there were no laws for such atrocities, and so these restrictions basically make provision for these people to be brought to justice. What the law says. Article 7, no punishment without law. No one shall be held guilty of any criminal offense on account of any act or omission which did not constitute a criminal offense under national law at the time when it was committed, nor shall a heavier penalty be imposed than the one that was applicable to the time the criminal offense was committed. Article 7, Clause 2 says, this article shall not prejudice the trial and punishment of any person for any act or omission which at the time when it was committed was criminal, according to the general principles of law recognized by civilized nations. So we hear that civilized nation is being used again. So there is a case here which anyone that is interested could explore. As a V versus Secretary of State for the Home Department, expert. It was Italy 2004. So this is a case where interested party can explore further. In all fairness, it's not that long, so I'll probably just for this particular time I'll just read out some sections of this case. It says a man convicted of various sexual offenses, including rape, was sentenced to 12 years imprisonment. He was released after serving 2/3 of his sentence, subject to license conditions, rules that must be followed after early release from prison, that applied for 3/4 of the original sentence. He had he been convicted and sentenced at the time the offenses took place, however, the legal provision then in force would have entitled him to temporary release without condition. He argued that his license condition represented a heavier penalty than was applicable at the time his offenses were committed, and that his right to no punishment without law had been breached. In all fairness, I'm going to read on, but I don't know how that is a heavier punishment. The House of Lords disagreed, yes, and then I'm not surprised. They held that human rights law will only be infringed if a sentence exceeded the maximum penalty available under the law in force at the time the offense was committed. That was not the case here, because even at the date of the offense, the maximum sentence for the rape was life imprisonment. The intention of the right to no punishment without law was not to punish an offender in exactly same way as would have been the case at the time of the offense. It simply ensures that a person is not punished more heavily than the maximum penalty applicable at the time of the offense. In this case, the imposition of license condition did not make the sentence heavier. than it would have been under the earlier regime. And so, just as I started reading the second part, I knew where it was going. I'm not surprised that the House of Lords disagreed, and therefore their positions were held to be true. And so, there you go. There is nothing wrong. That's right. There is nothing wrong. In all fairness, I need to explore this. I am hoping that this we're still in the ECHR, so bear with me a sec, because I'm seeing a lot of Human Rights Act. So I am hoping that this is we are still in the ECHR. So, okay. Right, I'm going to pause here because I need to really check that we're still in the ECHR. Article 2, right to life, freedom. Yeah. Oh, yeah, that's right. We're still in it. It's a right to fair trial. That's right. Because it keeps saying Human Rights Act, so I was indeed getting confused. Okay, so we move on to Article 8. But I'm going to pause. I'm going to pause on this. Okay, so Article 8 protects your right to respect for private and family life. Currently, as it stands, the PM, Sir Keir Starmer, is actually in favor of the review of this article, i.e. where illegal migrants are concerned in the UK. And so some aspects of deportation have come under a challenge by illegal migrants using Article 8 of the ECHR to basically restrict or resist deportation. But this, the Prime Minister of the UK, Sir Keir Starmer, is in agreement that this needs to be reviewed where illegal migrants are concerned. I think there was also the ridiculous issue where the shadow PM, being Kemi Badenoch, was actually advocating that legal migrants, the right to remain in the UK must be removed from those who hold that right. And so the Prime Minister's will to review Article 8 of the ECHR or advocate for it is definitely a practical and sensible choice on the basis of if a person is illegal in a country, then they couldn't basically exercise the same rights as citizens of that country, and such that there should be a clause, further clauses in that article that basically restrict illegal immigrants using Article 8 being the protection of your right to respect for private and family life. So Article 8 protects your right to respect for your private life, your family life, your home, your correspondence, letters, telephone calls, emails, etc., etc. That private life means you have the right to live your family. You have the right to live your life privately without government interference. Yes, indeed. The court have interpreted the concept of private life very broadly. It covers things like your right to determine your sexual orientation, your lifestyle, and the way you look and dress. It also includes your right to control who sees and touches your body. For example, that means that public authorities cannot do things like leave you undressed in a busy ward or take a blood sample without your permission. This is also an interesting one. So, for example, what does it mean if you go to do a medical and you have your doctor requesting for you to see obviously your body completely without clothes and maybe examine you in areas that may make you uncomfortable. How does that come into this right of private life? So this is also interesting. The concept of private life also covers your right to develop your personal identity and to forge friendship and other relationships. This includes a right to participate in essential economic, social, cultural, and leisure activities. In some circumstances, public authorities may need to help you enjoy your right to a private life, including your ability to participate in society. And so there is also the call on public authorities to ensure that this right is really indeed allowed, and where assistance is required, that they assist the individual to enjoy this right. But I would say that this right is solely applicable to citizens. So we go on to say, what family life means. Family life can include a relationship between an unmarried couple, an adopted child and the adoptive parents, and a foster parent and foster child. What home means. The right to respect for your home does not give you a right to housing. It is a right to enjoy your existing home peacefully. This means that public authorities should not stop you entering or leaving in your home without any good reason, and they should not enter without your permission. This applies whether or not you own your home. And so probably the only interesting aspect here is where public authorities seek to enter your premises without permission. And so nobody can enter your house, be it a police or a bailiff, without a permit or without a warrant to enter from a court. So this is a right that is applicable to daily life, and people must basically observe. Then we have a restriction to the right to respect for your private and family life. There are situations where public authorities can interfere with your right to respect for private and family life and home and correspondence. This is only allowed. Restrictions to the right to respect your family life. There are situations where public authorities can interfere with your right to respect for private and family, home, and correspondence. This is only allowed where the authority can show that its action is lawful, necessary, and proportionate in order to protect 1. National security, 2. to protect public safety, 3. to protect the economy, 4. to protect health or morals, 5. to prevent disorder or crime, and 6. to protect the rights and freedom of others. Using this right example, a physical disability team at a local authority decides to use support workers to help service users enjoy social activities, including visit to pubs and clubs. But when a service user asks to be accompanied to a gay pub, the scheme manager refuses on the grounds that the support worker was not prepared to attend a gay venue. Recognizing the human rights angle, an advocate working on behalf of the service user challenges this decision based on the right to respect for private life. Okay, that in itself not very clear what that really means. What the law says. This text is taken directly from the Human Rights Act. Article 8, right to privacy. Everyone has the right to respect for his private and family life, his home and his correspondence. There shall be no interference by a public authority with the excuse of this right, except such as is in accordance with the law and is necessary in a democratic society in the interest of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the right and the freedom of others. Okay, so we switch to this part of the ECHR just to simplify it and basically run through it very quickly. So Article 6, Article 8, the right to respect for private life is everyone has the right to respect for his private and family life, his home and his correspondence. There shall be no interference by public authority with the exercise of this right except such as, in accordance with the law, is necessary in a democratic society in the interest of national security, public safety, or the economic well-being of the country, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedom of others. So it's there here in black and white. We will carry on so we can run through these articles very quickly. So Article 9 is the freedom of thought and conscience. Everyone has the right. So Article 9, freedom of thought and conscience and religion. Everyone has the right to freedom of thought, conscience, and religion. This right includes freedom to change his religion or belief and freedom, either alone or in a community with others, and in public or private, to manifest his religion or belief in worship, teaching, practice, and observance. Freedom to manifest one's religion or belief shall be subject only to such limitations as prescribed by law and are necessary in a democratic society in the interest of public safety, for the protection of public order, health or morals, or for the protection of the rights and freedom of others. So obviously clause 1 tells you the right to freedom of conscience, but then clause 2 gives you some restrictions based on the items set in clause 2. Article 10, freedom of expression. Everyone has the right to freedom of expression. This right shall include freedom to hold opinion and to receive and impart information, an idea without interference by public authority and regardless of frontiers. This article shall not prevent states from requiring the licensing of broadcasting, television, or cinema enterprises. The exercise of these freedoms, since it carries with a duty of responsibility, may be subject to such formalities, conditions, restrictions, or penalties as are prescribed by law and are necessary in a democratic society in the interest of national security, territorial integrity, or public safety, for the prevention of disorder or crime, for the protection of health or morals, for the protection of the reputation or rights of others, for preventing the disclosure of information received in confidence, or for maintaining the authority and impartiality of the judiciary. And so once again, you get the 10 in clause 1, the freedom of expression, and then you get some restrictions that is in clause 2. And so, this article is basically protecting, in effect, what I am currently doing, just bringing this information out to the public for them to know, so that they can make informed decisions where, you have the likes of a political leader, the head of the UK Reform Party, trying to influence the public that they should actually encourage the exiting of the ECHR. This gives me the right to basically make this video, make this information public, so that people that are very busy to find time to read can just listen to these articles and know the contents of the ECHR, being the European Convention on Human Rights, and how that really helps their lives, and the importance of the UK remaining in it. In reality, it is only a very minor aspect of it which deals with obviously migrants and the removal of migrants, which is actually in Article 8, their right to a private life. This is the aspects that needs some sort of amendments to take into consideration that an illegal migrant cannot have the same right as the citizen. So these rights which are expressed in the ECHR are indeed rights that are basically reserved for European and UK citizens or citizens of the member nations of the European Convention on Human Rights. So Article 11 talks about the freedom of assembly and association. Everyone has a right to freedom of peaceful assembly and to freedom of association with others, including the right to form and to join trade unions for the protection of his interest. And so we see that in the times of the Tory administration, a Home Secretary like Suella Braverman wanted to curb the rights for people to demonstrate on issues that concern the interests of the people. These were sort of draconian laws that, could have been put in place based on UK parliamentary supremacy. So because we've gone Brexit, the parliamentary supremacy has become very powerful. That is whereby a political majority party could use their power to enact laws that can be detrimental to the citizens of this nation. Article 11, Clause 2, I'm sure will have some restrictions. It says, no restrictions shall be placed on the exercise of these rights other than such as are prescribed by law and are necessary in a democratic society in the interest of national security or public safety, for the prevention of disorder or crime, for the protection of health or morals, or for the protection of the rights and freedom of others. This article shall not prevent the imposition of lawful restrictions on the exercise of these rights by members of the armed forces, of the police, or of the administration of the state. And so all these articles, as you can see, that there are always restrictions, but this is why we have the judiciary, obviously the UK Supreme Court being the highest court of the land. We see here the issue of parliamentary supremacy when they try to, Rishi Sunak tried to push through the Rwandan law, and so these are some of the restrictions. Article 12 deals with the right to marry. Men and women of marriageable age have the right to marry and to found a family according to the national laws governing the exercise of this right. So this is plain and simple. Article 13 deals with the right to an effective remedy. Everyone whose right and freedom as set forth in this convention are violated shall have an effective remedy before a national authority, notwithstanding the violation has been committed by persons acting in an official capacity. So here we are. This is also a very good right that, and these are the reasons why I advocate that we remain in the ECHR. If there are minor aspects of it that needs reform, indeed, that is a conversation that has today been opened up by the head of the Council of Europe, what's his name again? Alain Berset. So he has said that he is willing to open up that debate for reform. That is what you need. But every aspect of this European Convention on Human Rights, upon which the UK human rights laws have been built, are good articles and they are good laws. And obviously, citizens of this nation indeed need to have that opportunity to seek remedy at a higher or external court or law in the event that they are denied justice within the territories of this country. Everyone has a right and freedom as set forth in the convention are violated shall have an effective remedy before national authority, notwithstanding that the violation has been committed by a person acting in an official capacity. So there you go. If your rights are infringed upon, then surely, based on Article 13 of the ECHR, you will receive remedy for any abuse that you have basically encountered in a country. So in the case that I presented in the previous videos where a young man lost his life in a UK prison and there has not been any accountability and they have indeed been denied justice, the family, where we saw that Article 2, Article 3 and Article, I think it's Article 5, his right to a fair trial were all breached. We see that under Article 13, if the European courts of human rights came to the conclusion that such rights had been abused, then the person would have been, or the family would have been entitled to adequate remedy under Article 13 of the ECHR. So Article 14, prohibition of discrimination. The enjoyment of the right and freedom set forth in this convention shall be secure without discrimination on any grounds such as sex, race, color, language, religion, political or other opinions, national or social origins, association with a national minority, property, birth, or other status. So this is once again a powerful article, and I will say it is rather ironical that somebody like the shadow PM, Kemi Badenoch, will like to basically like the UK to exit the ECHR. In effect, Article 14, which is the prohibition of discrimination, could be counted as one of the pillars that have probably helped her to elevate to the status of her political career where she is. And we can also say that also for the Deputy Prime Minister, which is Deputy Prime Minister who has also risen in ranks. And we can see that Article 14 indeed is very active in the UK, and it gives everyone equal right regardless of their sex, race, color, language and whatnot. And so this is why I continue to advocate for the UK to remain in the ECHR. Article 15, derogation in time of emergency. In times of war or other public emergency threatening the life of the nation, any high contracting party may take measure derogating from its obligation under the convention to the extent strictly required by the exigency of the situation, provided that such measures are not inconsistent with its other obligation under international law. So this will be, in the times of COVID, how people were basically restricted, where certain laws that protects the rights of individual or people in the citizens of the nations were set aside for these draconian laws to be put in place to curb or control the people based on public health emergency. Article 2, no derogation from Article 2 except in respect of death resulting from lawful acts of war, or from Article 3 and 4 and 7 shall be made under this provision. So you can see that it states very clearly. Any high contracting party availing itself of this right of derogation shall keep the Secretary General of the Council of Europe fully informed of a measure which it has taken and the reason thereof. It shall also inform the Secretary General of the Council of Europe when such measures have ceased to operate and the provision of the convention are again being fully executed. So you can see there once again in Article 15 very clearly whereby such rights may be infringed upon the head of the Council of Europe or the Secretary General, who is currently Alain Berset, would have been then informed and good reasons given why the ECHR should be set aside for whatever the reason, be it public safety or public health emergency. And then when that has ceased, then also he needs to be informed for the reinstating of the full rights of the ECHR to all citizens, in European Union and also here in the UK. Article 16, restrictions on political activity of aliens. So nothing in Article 10, 11, and 14 shall be regarded as preventing the high contracting party from imposing restrictions on the political activity of aliens. Article 17, prohibition of abuse of rights. Nothing in this convention may be interpreted as implying for any state, group, or persons any right to engage in any activity or perform any act aimed at the destruction of any of the rights and freedoms set forth within, or their limitations to the greater extent than is provided for in the convention. So once again, protection of the convention. Article 18, limitation on the use of restriction on rights. The restrictions permitted under this convention to the said right and freedom shall be applied for any purpose, shall not be applied for any purpose other than those for which they have been prescribed. Great. And so, we come to the end of most of these articles, but it goes on. It goes on. So we see here, we come to section 2 of the European Court of Human Rights. So we see Article 19, establishment of the court, number of judges. So this now goes into the details of the establishment of the European Court of Human Rights. Or it could be the European Convention. The European Court of Human Rights, yes. And so this is it. There are, as I mentioned earlier, there are optional protocols of the ECHR, which can also be explored by whoever is interested in. So this is the end of our video on ECHR. Once again, I encourage you to engage in this conversation. If you have any other reasons for which you think that the UK should exit the ECHR rather than this minor migration issue which needs reformed, of which the Secretary General of the Council of Europe, Alain Berset, is basically confirmed that he is willing to open conversation. If you have any other reason why you think that the UK should come out of it, then indeed the platform is there for you to engage in a conversation. Add your comments, put your comments, but be polite and respectful. Put your comments in the comments box, and we can all educate ourselves and have a discussion on this subject. But indeed, it is important that once again we don't lose ourselves and make another decision that we will pay a heavy price for in the future. This nation must wake up. the people of this nation must wake up and not be fooled once again to bring this nation into isolation and also lack of influence in matters in Europe or matters in this whole European continent. So thank you for once again engaging with our channel. As I mentioned earlier, our next video is going to be on the Renters' Right Act 2025, of which we are going to digest its content when it comes into force, how it impacts the relationship between landlords and tenants, how it impacts the UK housing market, and how it impacts UK house prices. So hopefully be on the lookout for our next video. Thank you for engaging with the channel. So that's it. Thank you for engaging with the channel once again. We've come to the end of matters concerning ECHR. I'm very sure that this is going to be, obviously there's going to be that next stage of debate, as we have heard from the boss or the Secretary General of the Council of Europe that is willing to engage in reforming some aspects of the ECHR, European Convention on Human Rights, that affects, the deportation of illegal migrants here in the UK and also in other European countries. I mean, we know from what he has said that it is not only the UK that is seeking this reform, but also Denmark, Italy, and other major players of the ECHR member states in the ECHR. And so a dialogue is the way forward rather than an exit, as he has expressed that an exit once again will place UK in an isolated state and also a position where we have no influence or have no say in discussions on migration that is affecting the whole European continent. And so hopefully this video reaches you and also inspire you to look into these international treaties and laws and conventions and how they protect your rights and my rights. And so thank you once again for engaging with the channel. As I said, if you have any comments, and you think that indeed we should still exit the ECHR just based on a minor migration reform and really not really looking at the whole picture of what the ECHR means to you and I, then indeed make your comments known in the comment section. Just be polite and respectful with your comment, and we shall surely engage in this conversation. So thank you once again for spending time to educate yourself on this channel. Until next time, our next video, which is on the Renters' Right Act in the UK 2025, be on the lookout. Thank you for watching.